I largely agree with what Alon has to say about the so-called trichotomy. I think this is a very important discovery. Apparently and I don't think I'd known this, in the antebellum period, social rights meant, well, natural rights as transmuted into civil society. They were called civil rights because civil society. They were called social rights because civil society. They were the same thing. That's correct. I'm going to disagree a little bit with Alon about the Reconstruction debates, and especially debates about the Civil Rights Act of 1875, and the question was this, what did this trichotomy mean? What were they getting at? And at one point he says that one of the positions I think Moulton took was incoherent. I think it's better to say what Alon said a moment ago, which is they were having an argument about the merits. But I think what the merits were about were not exactly about equality. I think that what people like Moulton were thinking when they talked, for example, about common carriers, the 1875 Act, what they were thinking was there was already a civil right of access to common carriers. But there wasn't a civil right of association with everybody else who might or might not want to associate with you. And that's social in another sense, not social as it goes with civil society, but social as it goes with associational, a word that appears at one point, crucially, I think, in Alon's paper. That Congress was seeking to confer new associational rights through the desegregation requirement if there was one, in the 1875 Act. I think the burden of the argument against it was Congress has power to enforce civil rights. This isn't a civil right, it's another right. It's an associational right to associate with other people. I agree with Alon that that's a question about the merits. I don't know that it's a question about the merits of what's equal and what isn't equal. Rather, I think it's a merits question about what is the content of the right that everybody has. That is to say, I think the people who were saying this were reproducing the thinking of the Supreme Judicial Court of Massachusetts in Roberts against City of Boston, where they said that having segregated schools is consistent with the right of education because everybody gets an education. And there's no additional right, what later became to be called a social or associational right, there's no additional right to go to school with anybody in particular. That right can be reasonably regulated to keep people apart. Whereas adding to that would be creating a new associational right. I think that's what they were getting at with distinguishing civil and social rights and saying Congress doesn't have the power to go farther and create the associational right because civil rights can be reasonably regulated. See, for example, the reasonable regulation of the right to go to school in Roberts against City of Boston, where again, the Supreme Judicial Court said, yes, everybody gets to go to school, but it doesn't mean the schools have to be integrated. So I think that's what was going on. It's not an incoherent position, it's a position on the merits. And as I say, I think it's really one of these questions about what is the content of the rights. Because remember, we're not talking about provisions that say there shall be no discrimination. We're talking about provisions that say everybody shall have the rights. Well, when the provision says everybody shall have the rights, the really crucial question is what's the content of the right? And if the right is limited to being able to get on the common carrier and there's not an additional right about where somebody sits, then adding an additional right would be adding social rights. Okay, now I'm going to get up. And talk about the other part, privileges and immunities, and what about public privileges like, for example, what are provided with the government's own resources, public privileges like education and crucially, oysters. And here is, there is providence in the world. This morning, I got up, I was going for a walk out here, and I saw somebody walking toward what I assume is public water here, carrying a rod and reel. And I thought, he can do that because he's a citizen of California, probably. I'm a citizen of Virginia, and I can't go fishing here any more than I could go raking for oysters. Why is it okay for California to say that only the Californians can take their rods and reels out here or go raking for oysters, Corfield against Coriel, and they can keep me out? Well, that's a crucial thing that Alon is talking about here and that Judd's paper is talking about. The reason I got up is because I'm now going to indicate 5 categories of legal interests. All the way over here are legal interests created by federal law that are not privileges or immunities of citizens. For example, being able to be incorporated as the first or second bank of the United States. Over here, now, slaughterhouse. Over here are privileges and immunities of distinctively national citizenship. Like, interestingly, and I think this counts in favor of Elan, using the navigable waters of the United States. Citizens of the United States could do that, said Justice Miller. Here is the Elan Werman, Judd Campbell, intermediate category of general citizens' rights, which are the rights known, the civil society versions of the rights known in the state of nature, property, contract, that sort of thing, say some, in an overlap zone, and this is the crucial thing, in an overlap zone where they go with both citizenship of the United States, or with being a citizen of the United States might be more accurate, and with being a citizen of the states. Okay, category 4 is privileges and immunities of distinctively state citizenship, as opposed to the general rights of citizenship or rights of general citizenship. And I want to stress, I'm not sure there's anything in box number 3. But Judd thinks there is, Elan thinks there is, so the box has to be identified. Now, all the way over here are interests created by state law that are not privileges and immunities of state citizenship. For example, being able to charter the Charles River Bridge or the Wheeling and Belmont Bridge. One of the questions, and now I have to go back into category 4 because this is the really interesting place to be. One of the questions that is central to what Alana's saying and what Judd says is, why is it that New Jersey can say people from out of state can't rake oysters or vote in New Jersey or send their children to the New Jersey common schools or participate in programs of social insurance like the Poor Laws? Why is that? For the 14th Amendment, antebellum period, generally accepted that that's okay. 2 possible answers to that question. One answer is, yes, they're privileges or immunities of citizens, but of distinctively state citizenship, and Article 4 stops here. Article 4 gets the middle zone, and I have to reach over to category number 2, Justice Miller, gets those 2, but Article 4 stops here, and it doesn't get to the privileges and immunities of distinctively state citizenship, like raking for oysters or going fishing out here. The other possible explanation for why I can't go fishing is access to access to a commons, or school, or voting, or the Poor Laws are not privileges or immunities of citizens at all. They're privileges in the other sense. They're privileges in the rights privilege sense. Now, the rights privilege distinction, which has to do with the government's own resources as opposed to private rights, absolutely fundamental, and in particular in the 19th century, absolutely fundamental to separation of powers. Because the executive branch could make decisions with respect to the government's resources, and therefore could exercise discretion, could have discretion conferred on it, answer to a lot of non-delegation problems, and could apply law doing something that looks a lot like adjudication. So yeah, the category of privileges, very important, however it figures into this part about the rights of citizens. Okay, which is the correct explanation, or is it always the same explanation? Maybe not. Which is the correct explanation for oysters, common property, public benefits, in-kind public benefits like education, and the right to vote? Elan wants to follow, with respect to education in particular, so this is Brown, Elan wants to follow the old approach and say, yes, those were privileges and immunities of citizens of the states, and Article 4 stopped here. And that's why out-of-staters didn't get that. But since the 14th Amendment operates within states, it forbids the states from abridging the privileges and immunities of citizens, privileges or immunities of citizens of the United States. Since the 14th Amendment isn't just comity, it operates in states, it operates with respect to the rights of distinctively state citizenship. The other answer is, no, they're all the way over here. They are privileges and not rights. First comment, I think I have 2 points left. First comment on Elan, it seems to me that Elan needs to mix and match theories of citizens of the United States in the 14th Amendment. He needs to use the tripartite division part of the old theory that worked through the tripartite division, but he also needs to say something that those people would have rejected, which is that the privileged immunities of citizens of the United States, they say that stopped over here. He wants to include their rights of state citizenship, I think correctly, but then I'm not so sure about the whole three-way division, because the 14th Amendment says, and when you have residence, you become a citizen of the state. So it seems to me that Elan is sort of accepting and rejecting parts of the old theory. The last thing I'm going to say, I think I substantially agree with Elan about voting rights stay over here. A lot of rights, including resources and in-kind benefits and social insurance, do go into privileges and immunities of state citizenship. But I think it's possible to devise a better explanation of why the line was drawn with respect to where it was with respect to Article 4 in the 19th century. It's really important to understand with respect to public resources type rights, schools and that sort of thing, that, at least especially as it was understood in the 19th century, the government had a whole lot more power over the content of those rights, what are the common schools going to look like, and so forth, than over the core private rights, as Caleb Nelson calls them, property, contract, the sort of the things that are clearly civil rights or clearly privileges or immunities. It seems to me that the best explanation for what went on in Article 4 is that the courts were realizing that a state government could put together a package, and the package required that somebody both contribute and get the benefits, contributing through taxation that would support the commons, that would provide the public education, and that was the reason that the out-of-staters could be kept from getting that, because they had defined the right such that the right was the combination of making your contribution and then getting something in the area where they had a lot of power to determine the content of the right. The last thing I'll see is, maybe that's true, maybe that's not, maybe it's a correct theory of what they were doing with Article 4, maybe it isn't, but the distinction between the power to determine the content of the right and the power to say who has the right is fundamental to the anti-discrimination mechanism of the 14th Amendment. Because it says, for a lot of rights at least, it's up to the state what they are, but the state then has to give them to everybody. It seems to me that the same phenomenon can explain what was going on under Article 4, and the last thing I'll say is that it is possible for us better to understand what was going on in the Constitution than people earlier on in American constitutional history, because we have the advantage of so much experience with this system, so in important ways we can know it better than they did. And Elan, please.
I don't know that I have much to say because I stopped listening I substantially agree with Elan, and I'm not sure what followed after. So I'll say two quick things because I think we largely agree. Maybe John's is a more refined way of thinking about it. So I hope you send me your comments so I don't just rely on the chicken scratch I have on my laptop. In terms of the debate over the content of the right and whether it's it's this new right, I don't think I disagree with that. I think it still ultimately boils down to the same merits question if by separating on the ground, separating the races on the grounds that they don't have this additional associational right, in fact creates civic inequality. That is still boils down to the same merits question, which I think you agree with, just maybe yours is a better way of saying it. I'm not convinced it's a better way of saying it yet, but I will have to think about that. And I don't think I disagree either that I think you said at the end that you agree with me that even if it's within the rights privileges distinction, that it's covered by the 14th Amendment because because state citizens by the 14th Amendment, or state citizenship rights by the 14th Amendment are brought in. Or did you think that public privileges are totally excluded? I didn't follow the distinction. If you don't mind actually clarifying, I don't know if others followed everything.
Probably not. I think, though, as I say, I think it's easier for me to say this than for you to say this. I think that the privileges or immunities of citizens of the United States include the privileges or immunities that they get through the state citizenship that the Constitution gives them if they reside in a state, and that the universal equality principle applies with respect to those. I think that a lot of public privileges are privileges or immunities, and this is something I cut out, so thank you for giving me the opportunity to put it in. That I think that the characteristic of public privileges that makes them privileges or immunities is that they are created basically to serve private purposes, which distinguishes them from the right to vote, from special incorporation, for example, where the special corporation, like the First or Second Bank, is serving a public purpose. They're created essentially for a private purpose, and they are very, very widely distributed, such that it's possible to say almost everybody gets this, but these people are being excluded from them. Those are the, and thank you for letting me get that in. Those I think are the two criteria.
Okay, great. Then I think we 99% agree. So I'm glad. I'm not sure why you cut that part out. Maybe because you thought we agreed too much on that. Because when you look at the state convention debates when they were in the Jacksonian era, adding equal privileges or immunities clauses, they specifically targeted corporate privileges, and they said what these new clauses mean, right? No law shall be enacted granting to any citizen, class of citizen, or corporation privileges or immunities which on the same term should not equally belong to all citizens and corporations. That's a formulation that occurred in a lot of these. They said if you grant corporate privileges, you must open the ability to apply for incorporation on the same terms, so everyone has a chance on the same terms and conditions to be incorporated. And so I think this covers Brown.
Because they came to see corporations basically as private instruments, as a form of the law of contract, rather than something being done for the public, like running the Charles River Bridge.
And so I think that applies to, I'm trying to pin down John. So poor laws in public education, same reasoning? Because if not, then Brown's wrong, right? He's nodding.
Yeah.
And so, okay.
For private purposes and very, very broadly available. I think
Right.
those are the criteria.
You can't let everybody be a bank of the United States or the state bank, but I think I think the reasoning you described applies to poor laws and plausibly public education. So, but it's something that I would probably have to think through a bit more.